All rise. Oh yay, oh yay, oh yay. The Court of Appeals for the 4th Judicial Appellate District is now open pursuant to call.
Good morning. Please be seated. The court will now call cause number 04-22-260 CR in the matter of ex parte Jorge Favian Dominguez Ortiz. Announcements, please, from counsel or the appellant. Good morning.
For David Shulman from Austin, representing the state of Texas.
Very good. If there's any split argument, I'm going to assume that you've already advised the clerk of court. And with that, I invite the appellants to begin.
May it please the court. My name is Rachel Garza, and I'm here on behalf of the appellant, Mr. Jorge Favian Dominguez Ortiz, in the present appeal. Operation Lone Star is designed to arrest, jail, and remove non-citizens from the United States. We're not here today to decide whether the criminal justice system in Texas is the best way to enforce immigration law. But if we are going to use the Texas criminal justice system, it needs to be done properly. This includes affording persons accused of crimes under Operation Lone Star the exact same protections any Texan accused of a crime is afforded. The state facilitated Mr. Dominguez's removal from the United States, rendering his continued prosecution unconstitutional. Mr. Dominguez was arrested on August 28th, 2021 for a misdemeanor criminal trespass. He was magistrated the next day where his bond was set at $2,000. He was held in state custody for over 30 days, and the state was not ready for trial during that time. For that reason, Judge Andrade granted Mr. Dominguez a personal bond, which secured his release. Upon being released from state custody, he was transferred to federal immigration custody and was subsequently removed. There are 3 specific actions the state took in this case that made Mr. Dominguez unavailable for trial. First, the state chose to contact immigration. Second, the state chose to honor the ICE detainer that was placed on Mr. Dominguez. And third, the state chose not to prevent Mr. Dominguez's removal. The state had tools to attempt to secure Mr. Dominguez for trial, and they failed to do so. In fact, in the state's brief on page 2, they all but admit that by saying the state of Texas itself took no concrete action to prevent Mr. Dominguez's removal.
Excuse me, counsel, may I ask a couple just sort of ministerial detailed facts?
Absolutely.
Did appellant request an earlier trial setting earlier than May 9th? 2022.
It was an earlier trial setting was not requested earlier than May 9th, but it is the state's duty to bring the defendant to trial. Mr. Dominguez did try to speed up his this process by filing a waiver of arraignment and asking for a pretrial setting.
Did you ask the state to petition ICE for an administrative stay or, or to petition ICE for deferred adjudication?
No, there's nothing in the record that indicates that. However, again, it's the state's duty in this case, and under Barker versus Wingo, the United States Supreme Court even says it's the state's duty and not the defendant's duty to bring him to trial. And in addition to that, ICE, Immigration, Customs, and Enforcement puts out these guidelines to work with prosecutors. And so these guidelines have been out for a long time. They're readily available to the prosecutors to be able to use them, read those tools, and work with immigration on securing the defendant for trial if prosecution's a priority.
I'm not sure if the record reflects this, but what is the typical length of time between when an unauthorized alien comes into ICE custody for deportation, and two, on, if you know, does the record reflect when the defendant was deported?
The record does not reflect exactly when the defendant was removed, and the state or the ICE has up to 90 days. So had the state worked with ICE, there's a possibility that Mr. Dominguez could have been in ICE custody an additional 90 days. And again, this is a misdemeanor criminal trespass. This is not a complicated case. It just takes a couple of witnesses. You know, the elements are pretty straightforward. It shouldn't be that difficult to prosecute. And the state had over 30 days when Mr. Dominguez was in state custody, didn't even have an arraignment hearing until December. And so about 4 months after arrest, that's when he had his first court date. And so the state really was not prioritizing prosecuting him. In addition to that, the state wasn't even concerned with getting the case resolved while Mr. Dominguez was in the United States. So like I said, the first court date, his arraignment was in December. And at that court date was when Mr. Dominguez got offered a time-served plea offer. And so they weren't even attempting to resolve the case until much further beyond Mr. Dominguez's, being in their own custody.
Counsel, if I could interrupt also at this point, once you were made aware that your client was in ICE custody, did you take any action to request deferred action or an administrative stay? Was anything done to that end?
No, but specifically because that's the state, those are the tools for the state to utilize. So the ICE toolkit, it's for prosecutors to take advantage of. It's not the ICE toolkit for defense attorneys to take advantage of. And so it really was not on us to make sure that Mr. Dominguez stayed here.
What have been the actions taken by the state in that framework to keep custody of an individual so they can bring him to trial? How does this compare with other defendants charged with different offenses?
All right. So with different offenses, you'd want to look at the seriousness of the offense, right? And so if it's a more complicated case, of course, maybe, complicated murder case, for example, of course, you'd not expect the state to be ready for trial within 30 days, right? This is the facts specifically to this case, with it being a misdemeanor, pretty simple. But in other cases where there is a more serious or more complex case, there are other protections worked into the to laws that secure those defendants. So for example, more complicated felony. Under 17-151, you wouldn't be entitled to the personal bond until 90 days. And so built into the framework, there's already more time for the state to secure those more complicated cases. In addition to that, there are statutes that prevent bond in certain cases. So if it's a very serious, very complex, case, then, a higher bond would be set,
So let's compare apples to apples. Are there other defendants charged with other misdemeanors where if there's evidence that the state took, different action to retain custody of the defendant during that same time frame?
So
unlike these particularly charged defendants?
No, in Operation Lone Star, they don't take, the majority of the people are charged with misdemeanor criminal trespass, class B, sometimes class C's, and they're enhanced to class A's for punishment purposes. But there's only been one trial in Operation Lone Star, and it was on May 9th, and the person waited in custody the entire time. And so the state has made no effort to bring any of these people to trial, including Mr. Dominguez, while they are available. They simply wait until the defendant is unavailable for trial before they decide to start moving forward on the case, which interferes with their constitutional rights under the United States Constitution and under the Texas constitutions.
Counselor, I have a question, and I'll have the same question for the state. As between prosecution and deportation, what do you think is the primary purpose of Operation Lone Star?
Deportation.
Thank you.
And this is specifically, it's shown in the record as well that deportation is the goal. The sheriff for Kinney County testified under oath in a prior proceeding that he will wait essentially as long as it takes for ICE to come get somebody. He'll wait 48 hours, 5 days, 10 days, 12 days to make sure that ICE comes and picks somebody up. And if ICE doesn't come and pick somebody up and he determines that they are a non-citizen, then he will take them to Border Patrol himself. So they are trying to get people removed from the country. They are not trying to prosecute anybody. And this presents a serious issue. If you're not trying to prosecute anybody, then you're not going to trial. Trial is the most basic right of an accused person to get to trial. And you're presumed to be innocent until you are proven, unless you're guilty. You're proven guilty at trial. And to completely stop trial from occurring, in this case, having a case pending potentially indefinitely in perpetuity, it just is completely contrary to the most basic constitutional rights in this country.
Counsel, is it your position that the defendants under the Operation Lone Star were treated differently from other defendants that are sent to ICE custody?
I don't know about sent to ICE custody, but in terms of how they're treated in the criminal justice system, it is completely separate, Your Honor. There's separate dockets, separate judges. Judges are brought in, judges are fired. They're held in separate facilities, miles and miles, hours away from their county of arrest. Typically, you're arrested in Bexar County, you're held at the Bexar County Jail, and you're brought to court in Bexar County. That does not happen in Operation Lone Star. You're arrested in one county, bused to Dilley, where you're held in pretrial detention, and then bused to Segovia, which is in Edinburgh. And when you're released,
Excuse me, counsel, could you reserve, you're interrupting the proceeding. Thank you. Please proceed.
and you're bused to a second facility in Edinburgh. And then when you're released, you're not even released through the county that you arrest originated from. You're sent to ICE or to Border Patrol and subsequently removed without a trial setting ever occurring. And the state has effectively stepped into the shoes of the federal government. So federal cases almost basically uniformly hold that when a defendant has been removed, he's entitled to dismissal in his case. And federal cases in Tennessee, Massachusetts, Florida, Iowa, and Arizona all say this. And the state has acted as the federal government in facilitating the removal in this case. And therefore, these cases should be and must be not only dismissed, but dismissed with prejudice.
Can I have a question for you? Oh, I'm sorry. So you just used the words purposely facilitate. So on this record, can you walk us through the steps, purposeful, deliberate actions of the state to support that statement?
Yes, Your Honor. So the record shows that Mr. Dominguez was in, like I said, state custody for over 30 days. The record also shows that upon being released, he was released to ICE. And he also, the state knew that he was a non-citizen from the day after he was arrested. So he was magistrated, and at that magistration, he notified that he was from Mexico, he was a non-citizen. So the state's known since August 29th, the day after his arrest, that he was a non-citizen and that he hadn't when he had his ICE detainer placed, they presumably knew that he would be transferred to ICE. That's a pretty clear indication that somebody is going to be removed. And so they made the choice to honor that ICE detainer, to facilitate his transfer to ICE custody. And so that's really how the state facilitated his removal in this case.
How would you respond to the state if their position is the feds put a hold on him? I can't do anything. They can come and get him. And so the fact that I have to let them come and get him and take him into custody because of a violation of federal law, what alleged violation of federal law is, on what authority can you rely on that that's actually a deliberate action on the part of the state?
Yes, so the state legislature has enacted what they call the anti-sanctuary city law, where they require state officials to honor ICE detainers within 48 hours. And so that's a state choice. It's not federal law that requires them to bring somebody to ICE custody or hand them over to ICE. That's a state choice. And so although maybe it's not this prosecutor's choice, it's still the state's choice that they have made this law. And the state, also the prosecutors, chose to abide by that law.
To be clear, though, that in this case, court is not asked to review the constitutionality of any particular state statute. Is that correct?
Yes, that's correct.
I'm going to give you 10 more minutes because you've been pelleted with questions. And of course, we do want to give every opportunity for each member of the court to inquire about these issues. But yeah, so that's clear. So you're looking at the state as a general whole and not just any alleged deliberate action by the county judge or the state district attorney, focusing on the activities of those stakeholders who are directly involved with the custody of the defendant during this time frame. Same question Judge Valenzuela has asked. What actions in particular, if any, does the record reveal?
So the record does reveal that Mr. Dominguez was transferred to ICE custody, right? And the record also reveals that the sheriff, although in a different case, he stated his policy. The sheriff of Kinney County is the person who Mr. Dominguez is under his custody and control. It's the sheriff of the county. And the sheriff has stated that his policy is to hold people 2, 5, 10, 12 days, as long as it takes until they're turned over to ICE. So it's that, the sheriff is a state actor who's relevant here, and he's stated his policy, and Mr. Dominguez clearly fell within his policy. He was transferred to ICE, just as the sheriff said his policy is. So that action is very direct. Also, the state's, the prosecutor's actions himself, he didn't make himself ready for trial. The only reason that Mr. Dominguez was released was because under 17-151, the state was not ready for trial within the prescribed amount of time that the legislature deems is appropriate for the state to be ready for trial.
I'm sorry, can you tell us where in the record we can find that? Was there an announcement of not ready, or where can we find that?
There was not. So there was a separate writ of habeas corpus filed in the district court, but the personal bond that was awarded to Mr. Dominguez is in the record, and it's signed by Judge Andrade from the district court.
Okay, and so that is a result of the state not being ready. That's the reason that is that indicated on the personal bond?
It's not indicated on the personal bond, but there was no personal bond agreement between the state and the defense. And so he was only granted a personal bond after that. It was a 17-151 writ had been filed, and Judge Andrade granted that because the state was not ready. And that's page 20 of the record shows the personal bond.
I've got a question,
Yes.
and let me switch around, unless are your answers, are
Yes,
your questions
yes,
answered?
Thank you.
Okay. Let me switch around because I have a little bit of a problem with your brief. You allege a due process violation under the Fifth Amendment, correct?
Yes,
You're not alleging the 14th Amendment because it's the 14th doesn't even come into play, correct? You in your original brief, you say, hey, Fifth Amendment violation. And then in your reply brief, you say, hey, these are the particulars and it's due process. Tell me why we should not consider that you waived that issue because it was not addressed in your original brief, but was addressed in your reply.
so it was brought up in our original writ of habeas corpus in this case. So we do in that writ allege Fifth and Sixth Amendment violations from the US Constitution, and then the 10th and sections 10 and 19 of Article 1 of the Texas Constitution. We do allege that in the original writ. So the state's been put on notice. So I don't think we've waived anything because the state has been put on notice of those particular issues.
So what about your brief? Isn't it a waiver of brief? And tell me why it shouldn't be.
No, because and I'm happy to provide supplemental briefing. We can provide supplemental briefing on this if Your Honor would like it. But no, we were specifically focused on the absentia, the trial in absentia that we thought was going to occur in that first brief. And then when we found out that really this was the first we heard that there was no trial in absentia was planned or going to take place, then we sort of shifted our focus in our reply to respond to the state's answers. But I think because we brought up those Fifth and Sixth Amendment violations in our original writ of habeas corpus, the state was put on notice and the issue was not waived.
So originally, what was your thought on the state trying him in absentia? What led you to that conclusion?
Yes. So on April 14th, 2022, we received a notice from the court saying that there was going to be a pretrial hearing on April 29th and a jury trial in person on May 9th. That pretrial hearing was turned virtual and there was a Zoom hearing there where the defendant testified. We brought up the writ at that hearing. It was heard, denied. Mr. Dominguez testified that he was in Mexico, unavailable. After that pretrial hearing, everybody knew at that pretrial hearing he was not available for trial. After that pretrial hearing, we received a second notice on May 2nd, letting us know again that he needed to be in person in Brackettville, Texas. And so there's really only two options that could result from that. First is that there's going to be a trial in absentia, which is what it seemed to be. The second would be that he'd have a failure to appear, warrant issued for his arrest, and his bond forfeited. And so that's where our thinking of the trial in absentia is going to happen here, which is unconstitutional. And the state has conceded that that would not be something that they would move forward with.
So you didn't learn until the appellee's brief that the state was not going to move forward to prosecute the defendant?
Yes.
In absentia.
Yes, that was the first time that we heard of that. The record doesn't indicate any other time that was brought up. It was not brought up at the habeas hearing. It was not brought up in any, briefing before the trial court. It wasn't until the state's brief that we learned that there would be no trial in absentia. So that sort of changed the course of our responses here and our argument here slightly, but really.
Well, it
Not
perhaps
entirely.
changed your replies, but not your original brief.
Yeah.
So,
Yes.
I mean, are you also, excuse me, are you also referring to the fact that your original brief perhaps was in response to what transpired at the trial court during that Zoom hearing?
Yes, because yes, it was because we had
Don't
no.
agree with me if you don't agree with me. I don't want to put words in your mouth.
No. I mean, yeah, when we wrote that brief, we were going off of what we knew at that time, which is what had transpired at the trial court. And so that included a trial in absentia. Once the state says there's going to be no trial in absentia, okay, then what is it going to be? Are we going to hold this case open in perpetuity? Are we going to be subjecting somebody to a bond forfeiture and a warrant for his arrest by no fault of his own?
that goes to my next question. So the courts has stayed this case right now, but once it gets lifted, you know, and there's an FTA at the trial setting occurs, there's an FTA. What avenues does an appellant have to challenge the forfeiture, to challenge his bond, his FTA? And if the case, so answer that first question, and then we'll go to the scenario if the case actually gets dismissed.
Sure. So there would be a civil suit for the bond money, and Mr. Dominguez would have to defend that civil suit from Mexico. And again, he'd be subject to additional hurdles to jump in this case by no fault of his own. He did not transfer himself to ICE custody. He did not deport himself. And so he would need to defend those civil proceedings. And there would be no, at that point, no avenue on direct appeal for us to address these particular issues that the writ has brought.
The state would respond, I imagine, that that an individual can do that from pretty much anywhere, right? However inconvenient, but deprivation, what is it by degree that we must determine that it certain degree is too much? So how would you respond to their position on this?
Right. So you'd have to look at the facts of the case, right? We're looking, Mr. Dominguez is an indigent defendant. He was found indigent by the magistrate judge, and that's why we were appointed to him. So we're putting extra burdens on an indigent defendant, all for a misdemeanor trespass charge. And so when you're weighing the severity of the underlying charge with the burden it's going to put on the defendant, and then the defendant himself, it really feels pretty egregious to be putting him through all of this.
So to play the devil's advocate as well, it framed in the sort of like a deprivation of counsel framework, a response might be, well, he's represented by counsel. He's represented by counsel now. He would presumably be appointed counsel at any stage where counsel is, he is constitutionally entitled to counsel. Maybe not on the civil side, but certainly on the criminal side. Isn't this more of a case about an individual's inability to be present after being accused and charged of a crime, to be able to attend trial? And those are two different lenses in my view. So how would you frame this particular case?
So I think it's both. The defendants can't be there. He can't confront his witnesses at the trial, but also an Arizona district court case in United States versus Loren Lazola said that a defendant's deportation presents a clear challenge on his access to counsel. So Mr. Dominguez is not in a different city or county. He's in a different country. And while we do have technology and things like that, it's not the same as being in person with your client and explaining things to them. So it does still present a clear challenge to access to counsel as well.
I'll ask another, but more on the constitutional realm. You've certainly have relied and provided a lot more. There's a lot more authority on the federal side, right? And to the extent that, to what extent, if at all, are your state constitutional claims different than the federal claims from your federal claims that you've alleged and briefed?
So I think they go hand in hand. These are basic rights that we're talking about: the right to be present at your trial, the access to counsel. And so I really think that they do go hand in hand, and that those federal violations also translate to the Texas constitutional violations in this case.
And does the Texas Constitution provide greater or less, or additional rather, can't provide less, but do they provide additional or greater protections than its counterpart on the federal side?
So it's, they encompass the federal constitutional rights. And I don't necessarily think it's greater, but it does encompass very similar rights in that case.
You have
I'm well
a minute
over
and
my
a half
time.
if you want to address anything else that we haven't had a chance to
Thank you, Your
inquire
Honor.
about.
I'll be back on rebuttal. Thank you.
Thank you.
May it please the court. Let me say up front, given the nature of the discussion and what's transpired this morning, if the court wants to give appellant more time for rebuttal, we'll have no objection.
I'm sure Chief Justice will give you the equal amount of time she gave the appellant.
Let me start by saying the record is completely devoid of any indication that anyone from the state of Texas, being the prosecution, ever asked for or indicated that there would be an attempt to have trial in absentia. Even the scenario which counsel advised you this morning kind of implies, well, maybe the judge was the county judge, but you simply cannot have trial in absentia in Texas.
Has Kinney County ever sought deferred action on any sort of, well, since OLS, since Operation Lone Star began?
To my knowledge, no. But I'd also say, to my knowledge, no one has asked us to.
How would you respond to counsel's contention that this is a tool utilized by the state and not one immediately accessible to an accused?
Well, number one, I noticed that the first exhibit to the reply brief is a thing called the prosecutor's toolkit or something ICE made. I know of no prosecutor that's ever seen it, Texas prosecutor. Certainly no one from Kinney County or the counties I'm advising, Kinney and Maverick, they've ever seen it. But the other thing too is, it is my understanding that anyone can come to the border and ask to be paroled in for a specific purpose, sometimes medical, very often court, but does not require the state's involvement at all. It can be that way. State,
Are you representing that the prosecutors were not aware of this option that they had, these options?
I have no idea. It was never an issue. I mean, no one's ever asked Kinney County to do it. And
I think the question was, has Kinney County ever sought deferred action in a case against an accused who has an ICE hold?
not to my knowledge.
And that's not limited to just then Operation Lone Star? Are you saying that in all other cases, that in this particular county, the district attorney's office has never utilized the tool of seeking or petitioning for deferred action from ICE?
I am, to be clear, Judge, I've been involved in advising them on certain legal issues, and I have appeared before this court as an acting assistant county attorney, but now they have a genuine assistant county attorney. I just don't know.
Is that something that your co-counsel can answer?
Would you like me to, Your Honor?
It's been queried by members of the court, so yes.
So your answer to your question is no, we have not.
Ever or in just these group of cases?
Ever.
Very good. And to Justice Rodriguez's question, is it your position that at least in Kinney County, that the district attorney's office is unaware of this resource in petitioning ICE for diverted adjudication?
If you don't mind, let me clarify one thing. I work for the county attorney, not the district attorney. We're strictly dealing with cases in Kinney County. Whether the district attorney has ever taken that action previously or not, I don't know.
With that disclaimer on behalf of the county attorney's office?
The answer to that is no, we have not, and as well, frankly, did not consider it. These individuals that are arrested in Kinney County and incarcerated in one of several different units, we consider to be held by the sheriff in Kinney County.
Can I clarify my question then? Does Kinney County have a policy of not seeking federal government's cooperation to defer action or to seek a stay of removal for the time needed to complete prosecution of a case?
We do not have a policy dealing with that, the question in particular.
Very good. Thank you. You may proceed.
I would also like to point out that Operation Lone Star has nothing to do with this case, right? Operation Lone Star is about money and funding. But to be clear, anything that's happening along the border with the guys in boats and extra people has nothing to do with this case. This case was started by a licensed peace officer in the state of Texas effecting an arrest in Kinney County. And in some ways, this is not unlike the cases that evolved in the 80s and 90s where the claim was a pretext stop. This fellow only got behind me and waited until my car did something wrong so he could search me. And the Supreme Court ultimately says that's not important. What's as important is, was there probable cause for the stop? Was there probable cause for the arrest? Same thing is here.
Counsel, appellant represents that Kinney County has a policy of ensuring that every defendant charged under Operation Lone Star has an ICE detainer and is immediately transferred from state custody to immigration authorities. Is this accurate?
Totally inaccurate,
Okay.
even by what counsel told you this
And
morning.
has a defendant charged under Operation Lone Star ever been released into the community as opposed to into ICE custody?
Without getting into the semantics, the answer is they cannot be by Kinney County.
They
Kinney
cannot-
County is required to cooperate with ICE, and if someone is a non-citizen, to turn them over to ICE.
Right,
Now-
so again, anyone detained under Operation Lone Star, had any defendant ever been released into the community and not into ICE custody?
No,
Very good.
but again, I don't think this has anything to do with Operation Lone Star. Any non-citizen who is arrested in Kinney County, ICE will be notified once Kinney County has reason to believe they're not.
And has there been any individual defendant accused of whatever crime, misdemeanor or felony, who has been immediately deported in lieu of being retained for the ultimate criminal prosecution to be tried and convicted and sentenced?
Not to my knowledge.
Very good.
Now, I will say that first of all, part of the, I think, underlying problem here is this idea that the state turned people over to ICE for the specific purpose of their removal, which is not a possibility. At the time someone is turned over to ICE, there is no guarantee that they will be removed. And in fact, in another case, which is, I think it's PD 016022 at the Court of Criminal Appeals, which this court addressed in Cifuentes 0421-00579 is Jesus Alberto Guzman Curapoma. And he was turned over to ICE, and he apparently convinced them that he had a prima facie political asylum case. And to my knowledge, he's still in the country. And at the time of the hearing in January of 22, he was in the country. So no one is turned over to ICE for any purpose other than complying with our state law, which says the public agencies are required to cooperate with ICE and assist in their policies and allow them into the jails to affect their policies.
And that action is deliberate in your mind, in compliance with state law.
Forgetting the pejorative is attached to it, yes, ma'am.
Very good. Thank
Counsel, just to clarify, can you tell us what action, if any at all, the state has done to prevent deportation and ensure that the person remains so that they can be prosecuted for the charges that are brought against them?
I know of none.
Okay, so the state in none of these cases has taken any action that is available to the state to ensure a person remains for their prosecution.
Like I said, I know of no case such that, but
Mr. Hackabill, does the state intend to prosecute these defendants, and in particular, the appellant in this case? Was that the
Yes,
state's
Amy.
intent?
Okay. It is my understanding, yes. Which is, if they weren't, there would be no reason for them not to dismiss the charges and be done with it.
And so going back to the toolkit very briefly so that we can move on, but you're saying, I think you've represented to this court that no prosecutor has seen it to your
No
knowledge?
prosecutor to whom I have asked about it has ever seen it.
And would you agree with me? Have you looked at it?
Not in, not enough to converse about it, Your Honor.
Okay, well, I'm just going to say, in this toolkit, it allows, it really gives prosecutors it's kind of a guide as to the tools that are available to them, especially when you're dealing with individuals who are not authorized to remain in the United States. And in this case, we have Mr. Dominguez, who is now in Mexico because he was in ICE custody and deported. Is that correct?
I cannot say, Mr. Dominguez Ortiz. Is that his name? He
Dominguez.
testified that he was in Cardenas, Mexico,
Mhm.
but this trial court overruled the objection to a representation. There's no proof of where he is.
Mhm.
There's no documentation showing that he was deported. There is documentation attached to the appellant's pleading showing he was turned over to ICE. But the same documentation exists in Mr. Kuropoma's case, and we know that he's in the United States.
Okay, well,
There's
we know that when the Zoom hearing occurred, Mr. Dominguez Ortiz was on Zoom from a city, someplace in Mexico.
we know that he was appearing from someone that had said was Mexico, but we do not know that. The record doesn't support that other than his statement. And
That's
I'm not
part of
trying-
the record.
Was
That's
there,
part of the record.
Yes,
His
I'm not
statement
trying
is
to
part of the,
disagree
wait,
about the sufficiency.
I'm sorry. for
I'm sorry,
interrupt-
Judge.
I'm sorry.
no, I was just going to ask, as I don't recall, was there an objection made during the Zoom hearing or some?
To the assertions, factual assertions by counsel, yes.
Okay.
And I guess my question is already this administrative stay of removal, that is a tool to keep someone who's not authorized to remain in the United States to stay and be allowed temporary relief from deportation. So that is something that the state could have done to keep him here if they intended to prosecute him. Is that right?
Yes, that is correct.
And that was not done?
That was not done. I would also say this, that to my understanding, there are more than 3,000 of these cases alone in Kinney County
Mhm.
that have been pegged as Operation Lone Star cases.
So
If-
so does Operation Lone Star have something to do with this case or not?
In my mind, no, not with the underlying case. To say, oh, Operation Lone Star doesn't exist and it has nothing to do with this, because but for the funding, certainly the overwhelming majority of these people from other countries would not have been arrested because there wasn't enough law enforcement down there to begin with.
I think I'm confused by your argument because the definition of Lone Star case, while you argue is not applicable to this case is enumerated among a list of cases which have been identified as Operation Lone Star cases, and you actually have put a number on these cases.
Yes.
So without a definition of what an Operation Lone Star case is, how can you itemize them in such a way that you've represented to the court that there are over 3,000 cases in Kinney County alone? So,
With respect,
yes, please.
the county will not be paid for the prosecution if it's not on the Operation Lone Star docket.
So is
That makes it.
So is
Operation Lone Star.
reimbursement?
No,
a
not
factor?
reimbursement. It's not reimbursement.
It's something you've represented to the court. I'm not making this up. You just said that the state will not reimburse us.
I didn't
in
say
such a way.
reimburse, Your Honor. I said
Well,
they
I'm
won't
sure
be
the
paid.
record will review what you said. but
I said they will
proceed.
not be paid. County will not be paid. In this case, the prosecutor who appears, Ballard Shapley, is an employee of one of the counties, not Kinney, part of the border prosecution unit, who's representing the state in hearings. I am not trying to say that none of these cases have anything to do with Operation Lone Star. What I'm saying, if the criminal case is initiated by a licensed peace officer in Kinney County, it's a run-of-the-mill criminal case. The fact that the court is getting funding from the state to have this docket and the prosecutors are being paid to represent the state, that's like any operation.
To that end, what steps have you taken to prosecute the underlying criminal case?
It's on the docket with several thousand other cases. As counsel represented accurately, there has been one criminal trial.
Counsel, how, once a person is deported, how are they supposed to vindicate their rights in court if they've been deported?
With respect, Judge, I don't think that's the state's fault or problem. There is no evidence here that Mr. Dominguez Ortiz asked for anything other than to be released on bond. He didn't ask the state to do something to keep me here. He hasn't asked the state to do anything to allow me to come back. And unless and until we start getting to a trial date and he doesn't appear, nothing can happen in this case at all.
Do you represent then to this court that if an accused charged with a crime, now a defendant in Kinney County, if their counsel requests the state to petition for deferred action, that the Kinney County will do so?
I
Or
would not
still- Go ahead.
not recommend it,
You would not recommend what?
that they petition the federal government for anything to do with any particular defendant.
Why would you say that?
It seems to me that the premise of the issue before the court as set out by the defendant is dependent on there being some requirement that the state do something, and there is not. There is also specific statutes, this anti-sanctuary law, that prohibits the state from doing anything to intervene, I mean, not intervene, but to interfere with ICE's activity.
Is that even if it is in direct contravention to an accused constitutional right under state or federal law?
I don't see how it is. He has a right to a trial, and he has a right to be here for trial, and that's absolutely clear. But unless until there's going to be a trial date, and we find out that he can't come in, And
Counsel,
if to-
there is a trial date though, right? I mean,
there is a trial date. It's not what they used to call a preferential setting. There's lots of cases there with trial dates. There's something like 50 cases on the docket on the day that they had the one trial.
right, but the bottom line is there is a trial date.
Yes,
Okay, so.
right.
How does the state intend to prosecute then if there's a trial date and this person is deported? Because the state didn't take any action to ensure that the person remained here to answer to the charges.
Well, the simple answer is they could not. The state could not move forward to prosecute.
So then this case will just exist forever indefinitely?
Let me clarify something you said to Justice Martinez. I would not in a vacuum recommend that the county attorney did anything. But if we have someone who asked to bring me back for these days for my trial, I would then absolutely ask the federal government to let that person be paroled in for purposes of trial.
So goes back to my original
Yes.
question. And now I'm not sure if you're consistent. Can you clarify?
In a general sense, I would not recommend it. But if someone has a specific trial date and says, I want to come back, help me get parole, I would advise the county attorney to do what you can to assist.
Very good. So in this case, if all the parties knew that the appellant had been deported, and we know that because he testified at his habeas hearing on April 29th of 2022, he was still subsequently set for trial on May 9th. Why was this done when the trial court and all parties knew that he'd already been deported to Mexico?
With respect, we don't know that. And
The record reveals.
He did not testify that he had been deported. His lawyer made that assertion. He did testify that he was in Cardenas, Tabasco, Mexico. But he never said I was deported.
Okay, regardless,
Yes,
everybody knew he was in Mexico.
I don't agree to that, Judge. He said he was in Mexico.
Does the state
So-
have the ability to obtain those records to determine whether or not he was deported?
I would presume, yes.
And so that has not been done to verify if the state has question about whether or not he was actually deported. That has not been done.
No, because in my mind, it has no legal significance to the criminal case. And since, I think,
But counsel, it seems as though you're making it very significant. So help us understand. I'm having trouble following what you're saying because there is some inconsistency. Did the state dispute the fact that Mr. Dominguez represented to the court at the time that he was in Mexico?
And for the
No, we
record,
did
I'm
not.
gonna
We had
add-
no-
excuse me, counsel. For
Okay.
the record, I'm gonna add 10 minutes to your time.
thank you, Your Honor.
Very good. Please proceed.
Okay, bear with me.
I
don't
know
get
I know there's a lot to take in, but I'm listening with as much purpose and intent as I possibly
Okay.
can. And there's been some inconsistency in what you've been representing to this court. And so I'm trying to either reconcile your statements.
Okay, let me
Okay.
take this a step at a time. There is one issue in this case and the two companion cases, number 258 and 259, worded exactly the same, that basically is dependent on the state having some requirement of doing something to keep a non-citizen from being deported. There is no such requirement. I would suggest that the inconsistencies in my answer have to do with individual situations. Would we do this in general? Would we do this for someone in a particular circumstance, et cetera? There are thousands of cases, only one came to trial, and even after this writ hearing, whether Mr. Dominguez Ortiz had been deported or not was of no importance to anyone at the state. It
Count-
wouldn't have,
Counsel, I'm going to ask you to brief that fully when the state files their SIR reply brief, which the court is permitted
yes,
to
ma'am.
address specifically this issue,
Of,
particularly what authority supports your position represented to the court here is that the state has no obligation, as you've indicated to the court. So if you're welcome to brief it,
yes,
because I know that there are other issues the court would like to address with you
Okay.
in the time remaining. I don't believe that that this position you're taking was fully fleshed out in briefing. So I invite you to do that in your SIR reply.
I will tell you,
Counsel, if I might go back to my question,
Yes, Your Honor.
because I
Okay.
don't feel like you were given the opportunity to fully respond. If you believe that there was perhaps some other inconsistency that was miscreated, please help me clarify.
what I'm trying to say is, if you take away the idea that the state is not required to do something, then there's an issue here. But none of the cases cited in the appellant's briefs show a requirement that the state do anything to facilitate someone staying here, and certainly not without a request from that person.
So what you're saying is that the state has no interest in following through with the prosecution of a crime?
No, I'm saying there are in Kinney County several thousand cases.
And only one has been taken to trial?
Yes,
Okay,
and even on this docket of May 9th, it was pretty obvious that Mr. Dominguez Ortiz was not going to be there.
why was it obvious?
They're saying, they said in the hearing, he's in Mexico. It's pretty obvious that he's not going to show up voluntarily for a thing. So with 40 some other cases on the docket,
Well,
why-
it seems to me that he did present himself voluntarily.
no, at the hearing, he absolutely did. He was there on Zoom. But
Okay,
I think if you look at that and he says he's in Mexico, we've got 40 some other cases. Why would we worry about one individual defendant and taking the initiative to try and get him back when we don't even know that he will go to trial? For all we know, someone could show up in the 40 some cases and demand a speedy trial, something that has not been done in this case or many other cases.
and so it wasn't done in the original writ either,
No,
speedy trial?
not to my knowledge.
Okay,
To my knowledge, no one in Kinney County has demanded a speedy trial.
okay, Ms. Garza made a statement in her opening remarks that every undocumented person has or should be afforded the same rights as a Texan. Do you agree with her statement?
Absolutely,
Thank you.
absolutely.
And let me follow up with that question in your answer. So if you're stating that the state does not have any type or is not subject to any type of requirement to keep a person in the United States, aren't you subject to the US Constitution to due process to make sure that a defendant gets due process, gets a speedy trial, et cetera, et cetera? And you, I mean, the state or the
Yes.
county for this matter.
I would agree, yes, absolutely. But look, if those were in writs in trial court, that wouldn't be a ripe issue yet.
Yeah, but
Or-
you would agree with me that this whole process with Mr. Dominguez has, a taste of inherently unfair issues.
Not representing Governor Abbott or the state of Texas in any way, I would agree. Do I like this overall thing? No, I think it's a waste of time and money. But that's not the issue here. It's certainly.
What do you think the issue here is, though? Because we're hearing two sides, very different sides of a story, and that's why we're all confused. So you tell us what you think the real issue is.
Whether the state was required to do anything to keep Mr. Dominguez Ortiz in the country for purposes of trial.
Okay.
And I think the answer is no.
Mhm.
And under state law, there are certain prohibitions that would, the government code cited in there, 752-056. If the county attorney were to do anything to interfere with ICE, $1,000 fine the first time. There's 3 cases here, excuse me, 3 companion cases.
Uh-huh.
Well, if he did it in 3 cases, for the second case, it would be a $25,000 fine. And for the third case, another $25,000 fine. So if they had refused to turn these people over to ICE, somebody's involved for a $51,000 fine for the first
Yeah,
day.
but this is not a refusal to turn people in ICE. This is pushing people to ICE to get rid of the problem.
No, I disagree.
Okay.
Well, but even so, if you're following the federal law and turning someone over to ICE, as you're required to do, are you representing to this court that there are not options that are available to you, such as the deferred action or the other option that you have to keep the person here? Because the county does have an interest in prosecuting for crime, correct?
Correct.
And so they have charged this person with a crime, correct?
Yes.
And so it is, I'm not understanding how you can reconcile the two. On the one hand, you're saying, well, we can't interfere, which I'm confused about, because you have some options saying, okay, we're going to turn this person over, but we would like to utilize our option to keep them here just so long until we are able to prosecute our case. And so I'm really having a hard time reconciling the two. Either you want to prosecute the case or you don't. And if you don't, then why is the case not been dismissed then? If the county has no intention of prosecuting, then why has it not been dismissed?
I would kind of beg off and say, not my pay grade answer, but everything you're saying is true. Now, I can't think of it. It was Judge Fuller, who was on the 8th court, was sitting as a trial judge, and I was demanding a speedy trial, and the prosecutor argued, but we've got all these other cases that are older. And the judge said, but he's the only one demanding a speedy trial. Nobody's demanding a speedy trial. No one has really asked for a trial. And to say that we would focus on this case instead of the other 51 that were on the docket the same May 9th.
Excuse me, counsel, your response is really hinged on the issue of speedy trial. Judge Rodriguez's question is not hinged on a speedy trial issue. She's listened to her question.
Yes.
It relates nothing to the speedy trial issue.
Well, it does, Your Honor, in that why would we concentrate our efforts and financial resources when no one is asking for a speedy trial?
You're talking about docket management and
Yes.
timing. The court is inquiring about the intent by the prosecuting office to proceed with the criminal prosecution with knowledge that the party accused is and very likely will not be present at trial. So it's not timing of trial. It's the right to be present at trial for all sorts of constitutional rights that an accused is entitled to. And I'll ask that we referring to these parties as these people from here on out. Very good.
I was referring to these three gentlemen. I'm sorry. There was no implication. And if I gave that impression, I apologize.
Very good.
To everyone. These three gentlemen are charged with misdemeanors, but this situation, I mean, I don't have any of the numbers because I'm not involved with the district attorney. Many of the people who are arrested are charged with felonies, such as human trafficking, et cetera. Well, this would apply to them too. The problem underlying this is the infrastructure in the counties to get a docket set and get cases set for trial and move forward. Over
And you're
which,
still talking about docket management, but it seems like you're not able to answer the question.
Yeah,
And
wait, wait.
I'm gonna add a few more minutes because I think that there's other things that we'd like to acquire. So I'm gonna add another 5 and then we'll take you back up on, well, no, you're done. So we're gonna just add a few more minutes here. Judge Alvarez has a question.
No, I
No?
want to follow up with your answer and with Justice Rodriguez's question. My question is, if you can't prosecute them, why are you filing charges?
it's a very good question. I cannot answer that.
And you, not you, but your client.
Would I agree that there's very little logic in this? Yes. But these dockets exist. Mr. Dominguez Ortiz was charged. And to be fair, let me say, I don't see how you can divorce docket management from any of these questions because that's the underlying problem. Whether there's 3,000 cases or 100 cases, cases must be given priority. And as Judge Fuller said, if somebody asks for a speedy trial, they go to the front of the line.
Okay, so let's talk about funding, and I apologize for this,
No, go
Justice Rodriguez. So let's talk about funding because you've got a problem with funding. So if you don't get Lone Star funding for these cases, the cases just stay in limbo, right?
No, what I was suggesting is
okay.
the reason they are on a docket that's styled Operation Lone Star is because that's where the money to prosecute all these cases comes from.
Right, so it's not the arrest, it's the funding that Kenny County's interested in when prosecuting these cases.
I would
right?
have to admit that, yes.
Okay, got it.
Look, I would also say there's one important fact that was brought up here. Part of the underlying argument against Operation Lone Star is that we're targeting people who are not citizens and trying to deport them. Well, as counsel said, the peace officer arrested this person, and it's not until the next day that the state becomes aware that he's a non-citizen.
Right,
So clearly, this person was not targeted because he's a foreign national, right?
but we don't know that. We just have a statement, right?
That's why I brought in made this argument about the pretext stops. The intent of the officer in arresting is unimportant if there's probable cause to arrest.
Uh-huh.
Even if the stop was a complete pretext and the cop stopped beside him for 10 miles waiting till he didn't use the blinker, that's okay if he didn't use the blinker. I think it's the same thing here. Unless and until this court is willing to say that the state was under any obligation to do anything, I think the appellant's issues fail because it's premised on that idea.
If we were to say so today, why would
I'm
that be
sorry,
wrong? As a
Justice-
matter of fundamental fairness, if we were to say, in our opinion, that the state was required to take some kind of steps to ensure the defendant's presence for trial, why would that be wrong?
Because state statutes don't agree, number one. Number two, I wouldn't disagree about the fundamental fairness, but we have statutes involved. And I didn't even bother to find out what federal violations there are for not cooperating with ICE. But county attorney, 72056 says if you commit a violation, which is not to cooperate, it's your resignation from office. You're disqualified from office.
How did ICE learn about the presence of Mr. Dominguez Ortiz? In
I'm
the
sure it's
facility?
because someone in the jail, and I need to point something else out. These facilities are the county jail. Kinney County, for instance, for all intents and purposes, does not have a county jail. It's not certified, so they can't put anybody in it. someone in law enforcement in Kinney County, the sheriff's office, notified ICE, we have a non-citizen in custody. That's the standard procedure for how this is done in every county in which I'm aware. But I also think that's required by the statute.
I have two questions for you. You said something about maybe 5 or 10 minutes ago that I just want to make sure I'm very clear.
Okay.
Your position is law enforcement arrested somebody, and I'm gonna go with your argument and
Okay.
put aside OLS, okay? Somebody from law enforcement arrests somebody. Somebody from the state charges somebody.
Correct.
They are brought to court. They stand in front of a judge.
Yes.
They're kept by the state and or the county,
Correct.
right? And then somebody from the government, another extension of the government, deports them. But it's their responsibility to request to come back here to face their charges. That's
No.
what you said, essentially.
They said they may.
They may, but my point is the government is doing all of these things. And at the end of the day, it is their responsibility, the accused responsibility to make the request so that they may come back to face those charges. That's what I heard you say, bottom line. Is that correct?
Okay. As to making the request to the federal government for parole into the country, yes.
That it's the onus is on them.
It's
To
not the
come
on-
back.
Not the onus, Justice Consuelo, it is this. Both sides can do things, but the request is who is required to do so? And that's neither. And as I hope I made clear, if someone says, I want to come back for my trial, I'll be ready for trial on May 9th. I need your assistance in getting parole. I would recommend the county attorney give that assistance. But just to say, well, we're going to try and keep people in the country, I think that is exactly what the anti-sanctuary law prevents, is we're supposed to report these to ICE, and then if they make bond, they're supposed to be delivered to ICE or surrendered to ICE, case would be.
So yes, the answer is yes, it would be their responsibility to come back. Otherwise, they have the bond pending, they have the case pending, or a warrant for their arrest, or all of the above.
But in essence, you're right. And I say, yes, but how is that different than any case where someone's on bond? It's their obligation to show up for trial. And in a general sense, that's the same
Well,
thing.
the government hasn't removed them from the country. I think there's. a
The
little bit of
state
a-
did not.
Okay, so this goes to my second question.
Right.
So there's been some federal cases that have been used to direct us to some precedent.
Hmm.
And essentially, when you look at the federal cases, bottom line, it looks like the feds are prosecuting, the feds are deporting.
Right.
You cannot do both. Tell me, right, the cases are saying you can't do both. You can't
Right.
prosecute and deport, and you have to choose which one you're going to do. If you're deported, the case is going to be dismissed, right? Tell me how this is distinguishable. Are you saying because this is the state versus the Fed? So in other words, two different arms, this is
Absolutely.
distinguishable? Okay, that's
Okay,
your
I would
position?
say that the cases you cite stand for the proposition that the feds may not prosecute and deport,
Right,
right?
so distinguish this for me, this
Because
situation.
the state of Texas has no choice other than to deliver these people to ICE. Whether they are removed is up to ICE and those facilities. And like I said, in the Curapoma case, that defendant is still in the country. I have no idea whether that's extremely rare or happens a lot, but the point is, when someone is turned over to ICE, it is not certain that they will be removed.
Okay.
All right, but the answer to your question is, I want to say the inverse of dual sovereignty, which is the feds can't do both. They had the control to keep the person for trial. They chose not to, and they had to dismiss. We don't have that control, and we don't have to dismiss.
So Kinney County, if they make the call to the feds, they have no control over that. They have no control over, hey, we have somebody here that could be picked up. Can you come pick them up and do with them what you want? There's no control over that.
There is no control because I can't tell you that a call from the state or documentation from the state would have any real impact. But I see the analysis you're making, and I would say Yes, that's there, but it's not required. And that's what's at issue in this case, in my opinion.
I had one issue I wanted to raise, so I'll give you another couple of minutes to respond. Thank you for your patience in answering our questions.
I appreciate your patience. Because
So to follow the scenario that Judge Valenzuela has shared with you, so an individual who's received bond and then that bond is forfeited, does a defendant have any avenue for review in the forfeiture of the bond, right? They can pursue a claim at that point, right?
yes,
Okay. Also, if there's an FTA and a warrant issued out for their arrest for FTA, failure to appear, that there's a claim that a defendant who fails to appear can make, and that at that point in time, correct?
yes.
Very good. So you argue that on appeal that the appellant's constitutional claims are not right, but you don't. You see, I wonder if you're neglecting what we've just agreed to, that an appellant's forfeiture of bail and warrant for arrest for an FTA is a right claim at that point. So how does that
Okay.
jive with your position taken on appeal?
The rightness, what I would say is the issue posed in the appellant's brief is absolutely right for disposition. But whether the defendant would be denied a speedy trial and all these other issues that you have raised are not right because they haven't happened.
So setting aside the speedy trial issue, there are other claims of due process, fundamental fairness, the right to be and appear for trial and to be confrontation clause, all the constitutional claims that have been raised on appeal. Why are they not?
Because those are trial issues. And there is no trial yet. In other words, we don't know that this person will be denied confrontation because they may be here for trial. I don't know that.
So if
We don't know there'll be a bond forfeiture because there's no bond here. There's a personal bond.
Very good. If the stay is lifted, is it your position that the county state is going to pursue prosecution, set it for trial, a defendant does not appear, that they're going to pursue a finding, a verdict
Mhm.
in absentia, essentially. And is that what you predict will happen?
No.
Do you
No.
find that that is something the county and state may pursue
I
after the stay is lifted?
I would expect not. In this case, I will allow that in some cases it might.
Why distinguish those cases?
Well,
Under what circumstances would they pursue prosecution?
well, as far as the failure to appear, again, I can only tell you what I would advise if asked, which is, why would you file a failure to appear and issue a capias for someone you know is without the country? It's silly. It's beyond silly. And as far as the bond, he's on a personal bond. I'm sure there's an amount, was it $2,000? But the
But
state,
I'm talking about the trial setting now. We're already talking about, we've already agreed that those claims are right.
yes,
At the bail hearing, the forfeiture, and the warrant after an FTA. Now, again, I'm focused on the prosecution, the criminal prosecution. Will it proceed after the stay is lifted?
well, I
Do you
would
bel-
anticipate based on procedures that we'll have a decision before the court, and presuming that you did not grant appellant relief and lift the stay, the state would certainly move towards putting it for trial. And that's all I would know. And it's really all I could answer. I don't really know about the other.
So that went back to my original question. So if the state and all stakeholders become aware that an accused is not available for trial,
Mhm.
that it will still it'll still pursue a setting of a trial setting and then still ask for announcements and proceed with a trial. We have case law about when a trial begins. So
Yes,
it's your position that Kinney County will proceed with trial?
They cannot. A trial in Texas cannot go in absentia unless the defendant appears for the trial and then voluntarily absents himself and the trial court makes the appropriate findings.
Which means then trial settings will not be set, is what your position is?
They might be set, but unless the person shows up, they have no meaning.
I think we're going in circles because I premised my question is that when all stakeholders know
Right.
that an accused cannot be present,
Mhm.
will a trial setting be set? Is that a yes?
I think that's a yes.
Very good. Thank you.
I've got, just to wrap up, I hope. So whose burden is it to prosecute a case? State. Assume with me that Mr. Dominguez is in Mexico, because
Okay.
I know you've said we don't know, and
Yes, I am not trying to say he's not or that he hasn't been deported. All I'm saying is the record really doesn't reflect that.
okay, so it's the state's burden to prosecute.
Yes.
We're going to assume Mr. Dominguez is in Mexico.
Yes.
You've just stated that he cannot be tried in absentia.
Correct?
So then the alternative is, well, let me ask you this. What is the state doing to bring Mr. Dominguez back to prosecute him?
I would say they're doing the same as they do in every case, which is to list him on a trial docket.
So they are not assisting him to come back, at least temporarily, to be present and defend himself?
Not to
For
my
his case.
knowledge, and also to my knowledge, he hasn't asked.
So then but you've just said it's the state's burden to prosecute.
Yes.
So then the alternative would be to leave this case open in perpetuity, right?
In a theory.
Or
yes.
dismiss it.
Or dismiss it.
But if it's not dismissed, do you think that the state's actions are consistent with an intent to prosecute?
Yes,
And how so?
because I believe that the only thing that state does in pretty much every case they've ever involved in is ask the court for a trial setting. Right? Different counties use different types of dockets, but the same thing comes down. Even if we agree it's going to be a guilty plea, in most counties, we get a date in the future.
So you're going to get a date
Right.
knowing that Mr. Dominguez is in Mexico and cannot enter the country lawfully. And you're just going to keep bumping it down the road. He's not here, not present, not present. Is that really consistent with an intent to prosecute?
You're asking me, it's a good idea. It's not. Is it consistent? Yes, because I certainly have had cases that appeared on 20 and 30 dockets before we went to trial. Now,
For different reasons, probably not because the defendant was.
very often for reasons I
in another
couldn't disclose to the court, but we're number 46. Why are we going to say my clients fled the country? I've been involved in one case where the first breaks, the defendant went to Mexico, right? And the judge continued.
Well, let me just ask you this.
Yeah.
Do you agree these are unique cases because the defendant can't return to the country?
I don't know that.
On
The
his own.
point, the point is, and again, I am not an immigration expert in any way. And I will tell you candidly, the only information I get is when I call up my niece, who's an ICE agent in California. And she says people can appear at the border and ask for parole. Now, that in my mind is a fact. So maybe you could do that and let him in. Now, would the state assist in that? No one has asked. And again, if someone is on a trial docket, even if it's one of 50 or one of 100, and he asks the county attorney to assist, I'm going to advise the county attorney, file the paperwork. But none of this has happened yet. And these are all theories, and I apologize if I have answered all over the map, but that's primarily, I would believe, because we're talking about possibilities, not what has happened. And in every case before I've been before this court, it's on what happened in the past.
Counsel, you'll have one more question from Justice Watkins.
To follow up on Justice Rios's questions and the scenario that she laid out. At what point in the process does a defendant have a constitutional right to fundamental fairness? When does that get triggered?
It's my understanding, Judge, you have to ask for what you want, right? Now, after a trial takes place, you can claim that this wasn't a fair trial. But my understanding is fundamental fairness would be part of a speedy trial motion. It's unfair to take me to trial because the state, not the courts, haven't done what they can to get me into trial. But again, until that happens, it's not right. If it had happened and someone was pushed to trial for all sorts of reasons, arguably that would be the reason an appellate court would say that violates Barker versus Wingo and vacate the judgment. It's just hasn't happened. Again, I'm not trying to be obstructive at all, but a lot of this, I could not answer in any case, and I certainly can't answer for the state of Texas on future policies.
Thank you, counsel.
Thank you, Your Honor. I appreciate your
so
time.
much. Thank you.
May it please the court. Legal status in the United States and in the state of Texas is not determinative, legal status is not determinative on whether you have constitutional rights in the state of Texas and in the United States. Mr. Dominguez's status, legal status, citizenship status does not determine whether he has the right to fundamental fairness, to constitutional rights, both under the United States and Texas Constitution. That includes the right to be present at his trial, the right to due process, the right to counsel. And if Mr. Dominguez is unavailable for trial, the prosecution has prosecutorial discretion and they can prevent this from going on in perpetuity. And they've refused to. They've continued to prosecute this case knowing Mr. Dominguez is unavailable for trial. I also have an answer to Your Honor's questions about who has the duty to make the request in this case. It's the state. In the United States Supreme Court case, Smith versus Huey, it originated out of Harris County. So it originated from a Texas case and it was a 2021 Supreme Court case. In that case, the defendant was in federal custody. The court said, quote, "The state must try to prosecute a person who is in federal custody, even if that person is out of state." So while Mr. Dominguez was in federal custody, in ICE custody, the state had the duty to try to prosecute him. And he can do that through what the Supreme Court outlines as a writ of habeas corpus ad prosequendum. And so the court said there, quote, "The state of Texas could and should file a writ of habeas corpus ad prosequendum to secure the defendant for trial." The state failed to do that here. There's no evidence in the record that they filed a writ of habeas corpus ad prosequendum. And additionally, on that same issue, federal courts are also consistent. And it's the prosecution's burden to request that the defendant stay here in the United States and continue the prosecution. In addition, a New Jersey state court case, so it was a New Jersey Supreme Court case, State versus Lopez Carrera, said that it is the key question is whether the defendant chose to appear, not the person's immigration status. And so Mr. Dominguez was consistently present for his Zoom hearings. He was choosing to appear. It was by no fault of his own that he was not present for trial. Rather, it was by the fault of the state. And the court there also stated that the prosecution can seek cooperation from ICE. Again, this is a state, although New Jersey, it was a state prosecution that the court said you can and should work with ICE to try to get the defendant here. And in this case, the state of Texas did not do that. And so when it's by no fault of the criminal defendant, and by the fault of the state of Texas that he's not here, it really just is not fair to continue prosecution. in this
May I
case.
interrupt you?
Yes.
How do you respond to the rightness argument made by the state?
Yeah, this issue is absolutely right. These rights would not be able to be vindicated after trial because there's not going to be a trial in this case. Mr. Dominguez is unavailable and the state's making no effort to make him available for trial. So if we are choosing to wait until after trial to handle these issues on direct appeal, we just won't get there. And in fact, I think this is a very similar issue that was raised in the Court of Criminal Appeals case Ex Parte Perry. And the court said that they allow certain claims to be raised by pretrial
Yeah,
habeas.
but that was a writ of habeas case,
Yes.
yeah, versus the ripeness. Tell me about ripeness. Do we have jurisdiction?
Yes, absolutely. This court has jurisdiction, Your Honor. The only reason why,
There hasn't been a trial, so.
right, and the only reason is because of the stay in this case, that trial date did not happen, and that one of the two options, whether it was a trial in absentia or whether it was the bond forfeiture and arrest warrant and a capias and all of that, that's the only reason why that did not occur, is because of the stay in this case. These rights are ripe. They're present. They're here. Mr. Dominguez.
So are you saying that they're right because there has been a violation or of the fundamental rights of the Fifth, under the Fifth, and I believe you have the Sixth Amendment?
That's exactly right, Justice Alvarez.
I have two questions for you. If Dominguez Ortiz is never brought to trial, what'll happen to this bond?
So if there's a bond forfeiture, there will be civil proceedings. His personal bond is for the amount of $1,500. So he would then, there'd be a civil suit for him to have to defend himself against, going after $1,500. He's an indigent defendant again. So that is something that would be potentially detrimental to him. So that is what would happen to his bond.
Okay. And question number two, if the charges are dismissed, what happens to his bond?
Well, he had a personal bond, so no bond money will need to be returned in this case, but he will be free of the charges in this case.
Can I ask you, there are certain documents, obviously, well, what documents would the appellant wish for the court to take judicial notice of?
So we've attached, as your honors know, an extensive amount of judicially noticeable documents, and all of those documents are judicially noticeable. And so we would ask that the court take judicial notice of all of those documents, and we are going to be providing supplemental briefing on this prior to the 10th, as your court ordered. So there will be additional briefing on this particular issue. But footnote 1 of our reply brief does lay out some authority for why all of those documents are judicially noticeable. The other thing too with those judicially noticeable documents that I just want to point out to your honors is one of them is a list of all of the cases in Kinney County and the cause numbers for those cases. And you can look in those court records and see in some of them, the ICE toolkit has been provided to the prosecutors in Kinney County through other filings. So they have seen this document prior to our reply brief or any briefing in this case. They are aware of it. And you can see that through some of those, not all, of course, and I certainly cannot speak for all cases and filings, but I do know that some of them that has been filed. Thank you so much, your honors. We'd pray that this court reverse the district court.
Thank you, counsel. The case has been submitted and an opinion will follow shortly.
Thank you.
All rise.